So today, we have a guest. One of my founding convictions about how to teach Canadian law about Indigenous peoples is that you need to begin with an acceptance of the reality and of the sophistication that exist within Indigenous legal traditions themselves. And the best way to do that is to bring in someone who can speak authentically from within an Indigenous legal tradition, to talk about a representative Indigenous legal tradition and let you ask questions about how that legal system works and how it deals with the kinds of issues that typically arise when people in society deal with each other. So today, we have Professor Darcy Lindberg, an assistant professor at the Faculty of Law, University of Alberta, whom I'm going to offer a gift of tobacco, and hope that he will share his teachings with us about, if I'm not mistaken, Plains Cree law principally. There will be time for questions at the end, and questions and discussion will count toward your class participation requirement. So feel free to ask them at the appropriate time, and he will tell you when that is. Because we have a guest today, I don't want to interrupt his presentation by taking our usual break at 5 o'clock. So the examinable part of today will end at 10 to 6, and if you need to leave at 10 to 6, feel free. If the session goes a little longer because of interest or whatever, that's okay too, but you're not responsible for purposes of the course for anything that we discuss after 10 to 6. So if you have somewhere else to be, please feel free to be there. With that, I'm going to shut up, none too soon, and turn the platform over to Professor Lindberg.
Thank you, Professor Wilkins, and thank you for allowing me to be here. I'm grateful to be on this territory of the Huron-Wendat, Seneca, and Mississauga is a new credit, among with other nations here. I am from Alberta, so it gives me particular humility, but also it's a privilege to be able to come onto somebody else's territory and talk about my family's legal tradition. And as you'll see, I'm actually going to tie it into where are we with Indigenous laws today and the uptake in Canadian law as well. So a fulsome mix, hopefully, of all these things. I appreciate this gift of tobacco as well. It is it's a legal procedure that is invoked in our communities that we just did as well. We have lots of laws around this tobacco that maybe I'll talk about a little bit in here as well, but for the most part, I'm grateful that I'm received in such a good way in this invitation to be here and to speak to you as well. So with this tobacco, actually, in our communities, there comes a commitment. So it's not that we're not supposed to be committed all the time, but there's a special sort of significance when you receive tobacco. You have to be on your best behavior. So I can't tell any jokes now in this. You can't laugh at any Sioux. I almost broke it there. I'm just kidding. I will joke around here, but yeah, it does elevate what we're doing here today when this is shared. So I appreciate it. So I'm going to talk a little bit about myself first as an introduction. I'm not sure if anybody was at the previous session at lunchtime. I'll try not to repeat. But I am an assistant professor at the University of Alberta. My family is Plains Cree, Métis, and Swedish Canadian. That's kind of like the general makeup of my family. My mom is Plains Cree. My dad is Swedish Canadian for the most part, with a quarter Métis Cree in there as well. So we grew up like in my mom's side of the family. So my dad was kind of like adopted our Plains Cree way of living, if I can speak to it like that. So really, we grew up within our family relations on the Cree side of our family as well. I practiced law as well, so I went to the University of Victoria, got my JD. I practiced in the Yukon Territory and was called to the Yukon and British Columbia bars. Did that for 3 years, and then I got pulled back into this kind of work, specifically on Indigenous laws, through my master's and PhD research. So it's interesting. I got into law. I'm not sure everybody has their own reasons for getting into the legal profession, becoming a legal practitioner. I got in there. I worked with our Indigenous communities in Alberta, with our First Nation Métis communities, and I just saw a lack of representation from Indigenous lawyers. In the first part, the second was just a worldview. So you did readings where Dr. Leroy Littlebear talks about worldview and gives an explanation of that. We saw representation in legal dealings with an Indigenous worldview just wasn't always present there. And then thirdly was this idea of Indigenous laws. So I could see we had our laws in our communities, but they weren't really coming up and being used day to day in dealings with the province or the Canadian government and that sort of thing as well. So I went back to law. I became a lawyer, and it was a wonderful experience, my practice. And then, but also there's just a lot of great work that actually we'll talk about going on in academia regarding holding up Indigenous laws, et cetera, et cetera. So I got pulled back into there. So it's been a really great environment there. So that's me. So really I'm going to focus on, I'll talk a little bit about Plains Cree law, and then we'll tie it into where Indigenous laws are today in Canada. A bit of an overview in this. And I wanted to share this picture up here. That's actually from the Yukon Territory in the top corner there. This tree has fallen, and it's nursed these other two trees that are, they're not thriving, but they're surviving, right? They're on there, they're hanging on. And I think about the history of our laws. You will learn, or you've started to learn in this course. Is it an all year-round course, or is this the first couple weeks? Yeah,
week,
yeah. So you're gonna.
No fault of their own. They have not learned.
Okay, so you'll learn about like the history of Canadian law on Indigenous peoples, the effect of colonization, some really terrible histories there. And our laws, they've just continued to, they've been influenced, they've been imposed upon, but they've continued to persist in our communities as well. So this is a good reflection, if I can use it as an analogy or a metaphor. We have a tree that has fallen, but it's done its best to nurse another generation that has grown up. And it may look like a feeble situation at that point, but you understand that this tree has also provided seeds for other trees that are on the bank as well. So we're coming out of this period of nursing in these really hard situations of Indigenous laws, and we're starting to see a resurgence, is what we kind of talk about it within Indigenous communities. So that's the first thing. The second one is this buffalo here as well. I'm going to talk about Plains Cree law a bit, specifically our laws around the buffalo and our actual relationship with buffaloes as well. And so that'll give us a point to to interrogate what do I mean when I say Indigenous law or Plains Cree law. It gives a wading into the pool of what we're talking here, both pragmatically and also just theoretically, like what is Indigenous law as well. So how it's going to look here, I've kind of framed it this way. I stole this idea from Murray Sinclair, so another person actually who was on your readings today, when he talks about from an Anishinaabe tradition, from what he was taught, you ask yourselves, who are you? Where did you come from? Why are you here, and where you're going? And so I've heard Senator Murray Sinclair talk about this a couple times, and he says this was actually teaching from his family, and it provides self-reflection and a foundation on how you're going to go about in life. And so I kind of think about this with Indigenous laws. For us to understand where we are today, we do have to center it in this way as well. So we have to think about who are we, like what are laws, what is the relationship between Indigenous laws and Canadian law? Where did we come from is an important question. So we're going to leave it for your learning with Professor Wilkins the rest of the time to talk about the deeper history of this, but we will, as a jumping off point, talk about the TRC and calls to action and how that gives another chance, another opportunity for Indigenous laws to be put up front and center. Has very specific implications for what you're doing here, your legal training and law schools in general and what they're doing. And then the question of like, why are we here? We're going to talk about how we access and understand Indigenous laws and how Indigenous laws make their way into the courtroom. So we're actually going to look at, see where is it being applied, and then where are we going? So I'm going to center this whole conversation around this idea of, can a rock provide precedence? I'll talk about it in a second. It may seem confusing at this point. But what I see is, I'll talk about our laws, Plain Cree law, in a story, and essentially what I see where we're going, if we have the ability to engage with this type of law, then we're at least on the right path with the holding up the revitalization and restoration of Indigenous legal orders in Canada. So that's kind of how I've centered this. There'll be plenty of time to ask questions as we're going, and I'll make room. But we do have this. I do have quite a bit of slides here, I'm sorry. And then when we get to the end of it, we can have open questions, and we can talk about the readings, if things made sense, et cetera, et cetera. We can use that knowledge you did with the readings and apply it to what you heard today here as well. So first of all, Indigenous laws, who we are. So what are Indigenous laws? So the first thing, there's this conversation about like, what is Aboriginal law and what's Indigenous law. And there was a nice breaking point, probably like, let's say 4 or 5 years ago, spreading back probably about, I don't know how long, where there was a tidy kind of like relationship. Aboriginal law was kind of like thought of as the law as it pertains to Indigenous peoples, to Aboriginal peoples in Canada. So that we have law firms that just deal strictly in Aboriginal law. And they were focused on, or they're continuing to be focused on, things like Section 35 rights, questions of the Indian Act, et cetera, et cetera. So basically how Canadian law has interacted with Indigenous people. So that was kind of the field of Aboriginal law. And then so when we saw this in the profession and also in academia, Indigenous legal orders popping up, that was kind of seen as like Indigenous law. So if that makes sense, we have Aboriginal law, so the law as it pertains to Indigenous peoples, and in Indigenous law, it's kind of like the legal ordering that occurs inherently, internally with Indigenous communities there. So there's overlap in these two. Indigenous laws, as you'll learn, are taken up in the Canadian courts through legislation, et cetera. So they do overlap. But that is kind of like, when you hear the term Indigenous laws, that's what we're talking about. So this is kind of getting blurred now because the word Aboriginal is kind of falling out of favor. So, like the federal government has changed. It used to be the Department of Indian Affairs, then it was the Department of Aboriginal Affairs in some sort of formation. Now it's the Department of Indigenous Affairs. The word Aboriginal is kind of like being replaced by Indigenous. So why this is important, what you're seeing with some Aboriginal law firms, they actually are starting to say, we practice Indigenous law. So it's starting to create a bit of more confusion now, because for people who think Indigenous law is the laws within communities, some firms are still actually just saying, like, they're just still doing like Section 35 jurisprudence, specific claims. So it's not necessarily this connotation of Indigenous law. Indigenous laws, they're not restorative justice. Aboriginal courts are healing programs. So the first kind of there was a wave of uptake of restorative justice or Aboriginal courts, and people saw that as Indigenous laws as well. So I think it's a reflexive thing that still occurs. Students in my classes at the University of Alberta do come in the first day, and I do have to say, if you're thinking we're just going to look strictly at restorative justice programs, that's not the case. We're actually delving into Indigenous legal orders in all manners, and we're doing theory, and then people get scared of that and they drop the class and they or that's not true, but there is a lot of work within Indigenous legal orders, and a lot of it is theoretical work as well. So it's not just limited to this. So of course, there are some restorative justice programs that are reflective of an Indigenous legal order, and so they do make part of it, but that's not the whole thing, right? So just want to set that out. So Indigenous laws, they may be anciently deeply rooted and sourced in the earth or the sacred. So if at lunch I shared a bunch of stories from my community, that we actually consider a lot of them as sacred stories, and we find law within those as well. So that definitely makes a part of Indigenous law, but it is not the only part, right? So to believe that that's only, for example, Plains Cree law was only stories and ceremonies, it would be doing a disservice because it's kind of like a romantic view of Plains Cree legal life. So we also have like recent legal mechanisms like treaties, agreements, bylaws, or legislation. So we have Indian Act, so for example, the communities that I'm related to are Indian Act bands, and they have chief and council, and they come up with resolutions like in a very Western democratic way, and those become law sometimes. And we still consider that Indigenous law. We don't say just because it comes from a different form that it's not Indigenous law. We actually include that as well. And then, so we may have Indigenous elements of Indigenous legal traditions and other sources of law like state law. So we do have an uptake of legislation, et cetera. But then we do have these other ways that have been held onto on how to create law, amend law, talk about law, et cetera, in our communities. So we have these strategies. I moved this slide, so ignore the number there. I just didn't update the number there. So as I mentioned, there was this question of thinking of all Aboriginal justice as Indigenous law. So we're moving away from these types of questions, like what is Aboriginal justice, to thinking about what are the legal concepts and categories within this legal tradition. So we're getting a better question that's getting at Indigenous law. What are cultural values? So for a long time, in the cases that you'll read, you'll see the language of the courts even change maybe. They'll talk about Aboriginal cultures or customs, and then we could start to see it getting more detailed in talking about Indigenous law or specific nations, their law as well. So the idea of culture, that's always been like a way to describe the way Indigenous peoples do things and how they politically or as governance or legally order themselves. So we've started to change that question and just ask, like, what are the legal principles behind what we used to determine a cultural value, which has been giving us better answers to those questions. And then before, there was this question of what are the cultural or traditional dispute resolution forms, and now we're starting to think about what are the legitimate procedures for collective decision making. So this was a significant thing that Carrie provided here, because before this was known as like, oh, there was a cultural teaching, the sharing of tobacco, and when in reality we talk about this as law. And so this was a part of a legitimate procedure that occurs that allows for legal dealings that go on with the sharing of tobacco. So how I can describe this, there's other nations that you may be aware of that have their own sort of traditions of sharing of tobacco as well. For us, our old ones, our elders, they talk about this as a contract. They say, if you share tobacco, if somebody takes it, and then they're committed to what they've received that tobacco for. So in our older teachings, what we used to do is, it wasn't the amount of tobacco that you shared, it was just that you did it. So it was, our older ones, they always talk about, they say, you share what you can. So if you're asking for something, it can be a little pinch. It can be a cigarette if people smoke, or it can be a whole pouch of tobacco. So it's the meaning behind it, right? It's not necessarily the value of it. And what it does is it binds according to our beliefs and our laws the receiver to what they've been asked for that tobacco. So what we do when we set up ceremonies, for example, we will approach our old ones, who are our ceremonial holders, with tobacco, and we give it to them, and we often talk about like what that ceremony is for. Let's say we're doing a sweat lodge ceremony, we'd go and we'd say, this is a law, we want this sweat for, I have a family member who is sick, and that lodge holder, because they accepted the tobacco, they'd be committed to doing that. So we say it's a contract because there's no other real terms there. It's part of our tradition that like you don't negotiate. It's not like somebody comes with tobacco and you're like, okay, I'll do this lodge, but can you bring, I don't know, can you bring that stew you make and oh, I want an honorarium as well. It's actually just a straight on, can you do this, and you accept it, they're committed as well. So we have this thing in our tradition, in our laws, where then it's up to me, let's say I was to take it, and Professor Wilkins is a lodge holder, and I provide it, and he accepts the tobacco. Then it's up to me to use my own sort of understanding of what sort of gifts I need to provide to make this happen as well. And so we have this whole other laws about gift obligation, that it would be up to me to be like, okay, and I got to provide this, and I got to do this, et cetera, et cetera. So you could see there's a legal process there in a tradition, but it isn't necessarily like what you'd see, for example, what you learned in your first year with contracts and et cetera, consideration, all that stuff. There's a different sort of mechanism that we use with this as well. So I like it when our old ones talk about it as a contract, and then when I went to law school, and I'm like, well, then we have all these other things. It's not like a contract, but it's a way to convey the sort of legality of sharing tobacco. It's an important thing. And then, before we used to talk about what are the rules and answers. So even just like, there's a lot of sort of romanticism about, I'll speak for a Cree law example, of like, oh, people just unreflectively follow old customs. That's why you see in court cases they talk about it as customary law. But when in reality we have legal procedures and principles that are very reasoned. So we're rational, intellectual thinking in these processes, and they're developing as well. And so what these shifts do in these questions, it actually allows us to have better conversations about law, essentially. So if you think about Canadian law, if we were just to say, what is Canadian justice? It's a great conversation that we could have. We'd kind of just be dancing around the philosophical outskirts of the question of like, well, what are the legal concepts and categories of Canadian criminal law, where we can start to get a little bit more depth with those questions. And so that's all we're doing when we're changing the questions. We're trying to get better answers about Indigenous legal orders. I'm just going to pause for a second. If anybody has a question there, we're going to go a little bit deep here as well, but I just want to give you a chance to formulate anything. Yeah?
So you say there's no sort of negotiations, but can you refuse?
That's a great question, yeah. So it's, there's other traditions in other communities, but for us it's like, there's a bit of like a background too, like if you're going to somebody who holds ceremonies, they've kind of committed, they've gone through actually a relationship, they've learned ceremonies, there's acceptance by the community that they're a lodge holder. So there is this kind of like background understanding that they almost always accept. But there are instances where people will say like, they'll actually take the tobacco and they'll say, well, here's what I can do. Like, I can't do this ceremony. Sometimes it's like really logistical. They're like, I'm out of town or something like that. But what I'm going to do is I'm going to commit to find somebody else, or I can give you other names. Or they will just say like, I want to accept this, but I can't because I'm too sick to do this, or those sort of things. So the refusal does happen, but it's kind of like but there's like the overall spirit of it is they're committed to when they accept it. The other thing is though, somebody like, you couldn't come offer me and be like, can you hold a sweat lodge when I don't have those rights? I would be like, I couldn't accept that tobacco. I'd just be like, you got to find somebody else as well. So if that answers it, there's an understanding implicit in communities and who can do these things, and you can refuse it. It's not like it's going to be a dangerous thing if you refuse it. It's more so a communicative thing, right? Yeah, that's a good question. Yes.
So, if an understanding is one that shifts the language from cultural practice to legal principle, would it be fair to say that law, in the way that it applies to Indigenous traditions and communities, is possibly more pervasive than it might be for Western or Euro-Canadian ideas of what law and its role should be? So, the reason I ask is because we think, as Canadian law students reading Canadian law, we think that legal principles and laws should be kept to be as limited as possible and not as pervasive. And that's why there's a distinction between law and cultural and normative behavior. To the extent that the language is shifting when we talk about Indigenous traditions to legal practices and legitimate procedures, is it fair to say that it's more pervasive than this legal understanding?
Yeah, so the language you're using is right on for what we're thinking with this, because it is that idea of we're talking about norms, we're talking about the normative, the legal norms of a community rather than just strictly being something that is either deliberated upon or positivistic. It's not written down. So there is this room with when we're thinking of Indigenous legal orders that it is going to include implicit law. So I'll talk about Val Napoleon's work in a bit. And implicit law is that there's actions that are normative in a community, and what they do is they set the grounds for coordinated understandings of how we're going to be together in a society. So it's exactly that. And so that's it. And in our, I talked in our other presentation, I don't want to repeat it here, but for Plains Cree, our legal theory is the word for law is weaving, and it means that actually you're going to lay down multiple threads that weave out law and give it strength. And so it is this idea that we have normative behavior that creates the strength of law within Plains Cree law. And then, so some of the academic thinking on that, some of my colleagues, they come from this very same sort of normative way of thinking about Indigenous laws. So where that does lead to problems, as you'll see, is in the cases. And so when a community wants to assert Indigenous law, Indigenous legal orders, there is an evidentiary challenge that must be overcome because they have to say, well, what are we going to rely on when we show this? We're going to rely on stories. Are we going to rely upon our songs? And we've seen that consistently in Canadian law, the challenge with that. But it's what you've pointed out there is right on with one of the lynch points, I would say, in the interaction between Canadian law and Indigenous legal orders. Okay, so we'll come back to this conversation because we will jump into those things that conversation brought out. But where are we coming from? So I had mentioned, I'm not saying like Indigenous laws came from the TRC. They've been practiced time immemorial. But this call for law schools specifically in the legal profession to engage with Indigenous laws was made explicit through the Truth and Reconciliation Commission's findings and the call to action. So the Truth and Reconciliation Commission, I'm not gonna assume that everybody knows what this is. This was the commission based upon the residential school experience of thousands of Indigenous peoples, and so we had this commission that sought the truth. There's two sides of this. There's the truth part of it, and they went across Canada over a number of years and just sought testimonies from people who went to residential schools and made this report. So a few things about that, because we do know like the findings and the calls to action. The TRC, it came out of a class action suit. So students, Indigenous First Nation students is actually really specific, who went to residential schools, filed a class action, and then this agreement was a result of it after years and years of negotiation in that action. What it leaves out is there was also they call them day schools. So residential schools were when kids were taken away and they lived at the school, hence the name residential. But we also had day schools where a lot of the similar harms occurred as well. And that was where students were going to school during the day and returning to their homes at night. And so there's a separate action that's actually going on for day school residents there. And this also has left out Métis people or people who are non-status, Indigenous, et cetera, et cetera. So it's a very limited action there. But what did come about this, we had the final reports. So the final report, one of the calls to action, or within the final report, it says Aboriginal peoples must be able to recover, learn, and practice their own distinct legal traditions. So a very trite observation. And then we see this idea of respectful relations requires the revitalization of Indigenous laws. So this translates into the calls to action. 27 and 28 say that law schools and law societies need to teach Indigenous laws. And then we also see in calls to action 48 the recognition and implementation of an Aboriginal justice system. So you can see this language again. They use Aboriginal in here, an Aboriginal justice system. Like we have to think about what that actually means, especially when we're thinking about legal orders as specific to Indigenous nations, and we have many across Canada as well. And then we see in calls to action number 50, the establishment of Indigenous law institutes for the development, use, and understanding of Indigenous laws and access to justice. So this is all to say we've been practicing laws within communities for a long time, but this is just that sort of formalization within law schools, law societies of Indigenous law being taken up. So, and then I just put this one on here. Actually, this is a colleague of mine that made this slide, just to show the interaction between these calls. So obviously, if we're learning Indigenous law in law school, it's going to open up more place for Indigenous laws to be practiced in the formal legal, as we know, the Canadian legal sphere, what you're going to be doing when you're done law school. And then it's going to support the idea of like Indigenous Justice Institutes, et cetera, and they're going to all support each other as well. Okay, so that's where we are. So here's the question I'm posing to you today. Is can a rock be precedent, or can it provide precedence? And so I'm not asking you to answer it right now. I just want you to think about this. And we'll go through the slides. We'll come back to it and we'll talk about it at the end. And what I mean by this, we have our conceptions of stones. I'm getting my thinking mixed up here. In Aboriginalism, in John Burroughs' readings, does he talk about like the law of rocks according to an Anishinaabe perspective? I read another article by his just yesterday as well, and I think I'm mixing them up. But we share that within a Cree tradition as well. We talk about the animacy of not just humans and animals and plants, but also with the land and with rocks as well. And I always kind of put this out there. It's not necessarily to think about like, I'm not sharing that here to make you believe what like my family believes, but I want you to think about the force of that belief. And that's really what we're talking about law. So if you think about Canadian law, there are people, we might have a diverse opinion on the animacy of a corporation. Tomorrow, the Supreme Court is hearing whether corporation has a charter protection from cruel and unusual punishment. So we might have varying thinking on like, is a corporate human? Can it have these protections? But what we do know is that it has a force, right? There's a force in law, and the Supreme Court might make another ruling on that tomorrow as well. So I would say if you can't, we have our teachings that teach us about rocks. You're not going to fall into them today, but it's also just to understand that these sort of like beliefs, they have force within our legal reasoning. So how can this rock be precedent? So this rock here, this is the Buffalo Stone child. That's what the rock is called. This is in southwest Saskatchewan on the prairies. This picture is probably taken about 1967, 66, 65-ish. And the man who's standing there is the late Wilfred Tutusis, so a Plains Cree person. Really a knowledge holder, held a lot of our stories as well. And so this rock here, it has specific significance for Plains Cree peoples because it has this story attached to it. And so I'll share the story here. So the story goes that there was a gukum. So there's a grandmother. That's our word for grandmother in Cree. And this story goes back to the time before we used horses quite a bit, before horses came on the prairies. And so in order to get around, we used dogs actually to do a lot of labor. And they had this travois, so the structure of wood that would carry things. And what this Cookham had was her grandson in this, all bundled up in the back of this with these dogs that were pulling it across the prairie. So they were gathering roots is kind of the way I was told the story. And for some reason, these dogs, they got startled by, in one telling, it's a buffalo are in the distance, and back in the day, it was like thunder when you could hear their hooves across the prairies. There's that many. So these dogs, they got scared and they scampered across the prairie. And this Cookham, this grandmother, was just distraught because her grandson had been pulled away with these dogs. And then she found the dogs, but the grandson was gone, and she continued to be distraught. So she actually, in one telling of the story, she goes to her elders, and they have ceremonies, and they say, oh, this is such a terrible event, but actually what we think and what we're being told is that this person will actually come back to us. So just have faith. And so what happens is this boy is on the prairies, and this herd of buffalo that was further away now has come upon where this boy has fallen out of his basket. And there's younger buffalo there, and they understand the relationship between buffalo and humans. The Cree hunt buffalo quite a bit. And so they're scared and also a little angry at this human, this Cree boy. So they're wondering what they should do, and they're thinking, should we be violent to it? Should we just leave it? And they're just going to leave the boy there. But then an elder buffalo, what it says is, it says, no, we have to take pity on this human, so we're going to take him up. So there's a longer version of the story that I won't get into. But what it does is they take this boy up. He's raised by the buffalo. So the Cree community where this boy came from hunts that same herd, and they see in the distance always in the dust when they scare buffalo in the hunt, they always see like this little boy, like its figure running around in the dust, and they kind of talk about it. They say, is that a ghost? Like they don't understand it. So the story goes on as this boy gets older. He is able to see after a long rainfall one time. Buffalo, they used to like rub their backs in the dirt and create these huge mounds of like just dirt there. And so there's this huge rain and it forms this puddle. He sees his reflection and he sees that he's not buffalo, right? And so he asked this older man who had taken him up, and he says, yes, you're human, you're actually part of them. And then he says, and you have autonomy. You can actually go back and live with the humans whenever you want. And so the boy who's seen the Cree people hunt buffalo all the time is actually angry with his community and chooses not to. But eventually is overcome by the curiosity of living with the humans. And so he chooses to go back and is reunited. And this old lady is still alive, and she's overcome with joy that this boy has been found. So that's not where the story ends. What occurs is he lives with the Cree people for quite a while, but he still just cannot fathom why they're hunting buffalo, why they are nourishing on these peoples that he's lived with, and he's seen they've had a society, and they have like emotions, and they have families, and all the same things that the Cree share. And so eventually he just gets angry with that, and he returns back to the buffalo. He's like, I can't be a part of this life where I'm living on these people. So in some of our teachings, we talk about animals as their own sort of nation and people. So he says, I can't understand why I have to live on the people who raised me. So he goes back and he lives with the buffalo. And what comes of that is he continues to be hunted. He's so angry. And again, he goes to this elder buffalo and he says, I'm just so mad at the humans. I can't believe that I don't get why they hunt us. And so finally, the elder buffalo sits him down and shares this. He says, well, you might think that this is just a hunt, that this is just kind of naked aggression towards buffalo people, but we actually have a law together. And the law is that humans, when they came to this territory, they were naked, they couldn't feed themselves or clothe themselves, so they relied upon other animals like us for survival. And so that was part of our gift of life, is that we agreed to provide this for them. But in return, what the Cree people, the humans, what they need to do is they have laws as well. They have to respect us, they cannot overhunt us, and they have to hunt us humanely as well. Furthermore, they have to provide gifts for us when they take our lives. And then another law is when they do their ceremonies, they have to always keep us in mind, and we have to play a central part in their ceremonies as well. And so this is one story that explicitly talks about law in it, right? We have legal relations. Heidi Stark, who was here before, I thought she would be here, so I'd get to pick on her some more. She talks about these kind of like stories as being treaty stories. It's creating a treaty between animals and people, and that's the way Plains Cree people talk about this story as well. It's a treaty story between buffaloes and humans. We have this idea of law there, and then it doesn't sit on its own. So we have that story, but when I hear that story, because I've taken part in our ceremonies, I've seen how we've used like buffalo skulls for our ceremonies and the significance of that. I've heard other stories talking about buffalo. I've been a part of a hunt, even though I wasn't doing the hunting, I was just there. But I could see the respect that we give when we take a life and those sorts of things. I have a drum and it's a buffalo hide. And in our teachings, the belief is that that drum comes alive when we're using it as well. I can start to see how this story connects to all these other laws that define our relationship with buffalo, right? And so it creates that relationship. So how this rock comes into play is this is actually a touchstone for that story. So the story finishes that Buffalo Child was still just caught between these two worlds, and the older buffalo says, well, I'll tell you this. I'll give you a way where you can shapeshift into a buffalo and be a buffalo forever, or you can be a human. So does this protocol in the story, but then says, but if you want to be neither, then if you do this other protocol, then you could just become a stone. And so in the story, the boy becomes a buffalo and then has to face that reality that it's going to be hunted, and then does this other sort of protocol and becomes the stone on the prairies here. And so this stone, it's called Mistasini, which is essentially big stone in our language. Or it's also known as like the Buffalo Child Stone because of this story as well. So it's there. So that story, we know it now because it's been kept alive by our older ones. But before, people would actually go to this place and to retell that story. This is a place, it used to be a converging area for a lot of Indigenous nations. So this story isn't only known by Cree people, Blackfoot peoples, Saulteaux, Ojibwe, Métis, Stoney, Dene. There used to actually be a summer gathering spot here. And so they would share law and ceremony, and I'm sure this story was retold there as well. So what happened to this stone? So in 1867, they were making the Gardner Dam on the South Saskatchewan River. And this is at the elbow of the South Saskatchewan in the Qu'Appelle, I believe. And So instead of just leaving the stone, what they did is they tried to blow it up. So the Canadian government decided they're going to try to blow up this stone. They did. They've cracked it in half. And then they flooded the area when they made the Gardner Dam. So there's a lake in Saskatchewan, Lake Diefenbaker. Is anybody from Saskatchewan here? Yeah. So there's Lake Diefenbaker, that's in Saskatchewan. And this is underwater. It's 20 feet underwater in Lake Diefenbaker now, the stone. So it's submerged. So pretty prescient metaphor for Indigenous laws in Canada as well. Submerged underwater, tried to be blown up, but it's still sort of persisted. So within the last couple of years, people actually dived down to the stone and have taken pictures of it as well. And it's also ironic because Leif Diefenbaker, if anybody knows Canada's history, was he was a prime minister who came from Saskatchewan and is actually, as a practicing lawyer, was one of just an outstanding advocate for Indigenous peoples within the Saskatoon area as well. So, and now he has this lake named after him where the stone is under. So we'll hold on to that question. How is this precedence? And then we're going to drop back into, I guess, a more 10,000 foot level with Canadian law here. So we have inherent law. So I share that story. That story was shared countless times for countless generations by Plains Cree peoples. So the law exists. And then we have, how does Indigenous law start being a part of Canadian law and taken up? So we have one source is the Constitution Act, and especially in 1982 when Section 35 gets entrenched in the Charter, and 35.1 recognizes and affirms Aboriginal and treaty rights. So we could start to see case law. Canada, or the federal government and the provinces, they don't come to an agreement on what this should look like. So there was these first minister meetings right after 1982 where they actually tried to interpret what this was going to look like what does an Aboriginal right mean? And they all sort of failed to give meaning to what this is gonna be, mostly on self-governance. So Indigenous peoples were saying, we want the right to self-governance recognized through this, and there just wasn't a consensus that was reached. There were some things. This Section 35.3 through these First Ministers Conference came out that says a modern agreement is going to be deemed a treaty. It's going to have this constitutional protection, and then there's another provision about the equality of Aboriginal rights towards women and men as well that came out of these conversations. So they weren't fruitless, but they failed to give an understanding of what Section 35.1 is. So what that does, it leaves the courts to make these interpretations on what an Aboriginal or treaty right is. And so that will be taking up a lot of your time throughout this course. So for the purposes here, though, we start to see this language start to get inflexed into these cases, these Section 35 cases. So Vanderpeet talks about traditional laws and traditional customs and gives a little bit of definition for that. These things passed down and arising from the pre-existing culture and customs of Aboriginal peoples. So talking about tradition in a legal sense and then traditional customs. So the language is important here. In Delgamuukw, so a year later, it says that we have to consider the Aboriginal perspective, and with that, it also includes traditional laws. So again, that language is being replayed here. And then we have this Mitchell case where it's saying Aboriginal interests and also the customary laws are presumed to survive the assertion of sovereignty. So Indigenous law is presumed to have survived sovereignty, the assertion of sovereignty in Canada. So there's consideration. There isn't much definition of what the court means by traditional laws in these cases, but it is leaving the door open for Indigenous laws to play some sort of role in Section 35 jurisprudence here. So that's the foundations. I'll get to actually where we see cases taking us up, but first I just want to talk about other kind of like, we're stay at the 10,000 foot level here, where we see federal, provincial, or territorial legislation engaging with Indigenous laws. Some legislation attempts to incorporate Indigenous legal concepts and principles. So the Nunavut Act does this. It tries to incorporate, I would say, like Inuit law from the Nunavut territory there. And then we have legislation that either permits or requires engagement with Indigenous laws as well. So the Canada Human Rights Act, we have the Family Homes on Reserves and Matrimonial Interest or Rights Act. And then we have Bill C-92, which is respecting First Nations, Inuit, and Métis children, youth, and families. So this came into force 21 days ago. And we actually have seen the first, right after the first challenge by Quebec to this act on a question of federalism as well. That'll get into in a second. And then we have legislation that recognizes or enables lawmaking powers. And so the Bill C-92 does that as well. So this is just an example to show you that with agreement or advocacy with Canada or provinces or territories, there are ways that legislation is starting to make room for Indigenous laws through incorporation, for permission, I guess, so to speak, and then are also just enabling lawmaking powers. And so there's just a couple examples of these. So the Canada Human Rights Act, it says that this act will be interpreted and applied in a manner that gives due regard to First Nations legal traditions and customary laws. So saying that there can be some sort of interpretive issue with Indigenous law here. The Bill C-92, so this act that has just come into force, it affirms an inherent right to self-governance. It includes authority for Indigenous governing bodies to draft laws around child welfare and family, to administer and enforce law, and then to provide dispute mechanisms as well. So a fairly robust uptake of Indigenous laws. And then it says that Indigenous laws, according to this, will have force of law as federal law. And then be paramount over other federal laws except for the Human Rights Act, and be paramount over provincial laws as well. And then they're subject to the Charter and the best interests of the child, which we won't go into detail here. So like I mentioned, this is actually being challenged by the Quebec, the province of Quebec, because they're saying that the federal government doesn't have the head of power to provide, to enact this law and to provide this sort of powers to Indigenous governments and also organizations as well. So we'll see how that plays out in the courts. And then we have cases that where Indigenous laws have been brought forth and have been taken up. So we have a case in Nunavut, 2018, which is an interesting concurring reason that I'll talk about in a second. Beaver and Hill from this province in 2018 as well. We have a treaty interpretation case, Stool and Canada, 2018 again. We'll talk about a little bit more in detail. A case from back home where I am, Pastan and Denitha, 2018 again. And then we have these other ones in 2019. So these are fairly recent, obviously. So just so you could see that courts, we'll look at the language here, but they've moved from this idea of like traditional custom to like talking about like Indigenous laws, Indigenous legal orders, have really taken up this language that lawyers and academics have pushed forth with Indigenous laws here. So there's other cases that have considered Indigenous laws, but we're starting to see the language really be robust in these cases nowadays. And so I'll talk about the Pashtun case here. They are, in this case, it was a question of an election act provision within the Denetha community. So the Denetha community is in northwestern Alberta. And they, according to the Indian Act, were given control of their election code and also the appeals process to their election. So they're an Indian Act band, they're Treaty 8. And so they have this code, and Joe Pastian, wasn't satisfied with the results, and he thought there was some wrongdoing in the election. I actually worked in the Denetha First Nation as a youth worker. I know everybody who's involved in this case, so I'm kind of like, oh yeah, this is like an internal conflict that was going to happen here. So essentially, they had an election for chief. There's 3 people who ran. One person won. The second place winner was Joe Pastian, and he felt that the third place winner shouldn't have been allowed to run because they didn't live in the community, essentially. So was appealing on those grounds. Appealed to an internal process of elders in the Denetha community. They said, no, this election stands. And so then started this action in federal court to get that ruling overturned. And so Justice Ramond says that Indigenous legal traditions are among Canada's legal traditions. They form part of the land. And essentially saying Canadian courts have recognized the existence of Indigenous legal traditions and have given effect in situations created by Indigenous law. So we have these cases that they're referencing that are historic cases that are important. So it's important, the language here is just talking about Indigenous legal traditions, isn't saying this is custom, et cetera, is actually entering this robust language of Indigenous law. So the decision, by the way, was based on, as an Indigenous legal tradition, we recognize that Denetha legal process holds the decision makers with the most expertise to make a decision there. So is really given deference to Denetha law here and the decision makers. So if you think about administrative law, it's that idea of deference. We're going to give deference to decision makers with expertise. That's kind of like along the lines of what they decided here as well. And then this Nunavut case, IPAC, Justice Berger in a concurring decision. This is an interesting one because it's a charter case. It was seeing whether provisions of the charter apply in Nunavut. And Justice Berger just says that Aboriginal legal principles and perspectives on criminal law and the application of the charter must be taken into account in the pursuit of the objective of mutually enriching and harmonizing Canadian and Indigenous legal orders. So it's saying that there's Inuit law here that we also need to be considering in charter challenges. So it doesn't really affect the decision because we already have a majority decision here. This is a concurring one, but is just saying that we need to consider Inuit law when we're making decisions up here. And then there was Stool Case. So this, I'll never understand if I'm saying this correctly. Is it Ristuli or Ristool? I think I've heard it Ristool, but. So this is from Ontario here. And this is a question of treaty interpretation. So we have Robinson Huron treaties, and what was the common intention of the treaty makers was the question. So it's a long decision, and we won't talk about what they decided here. They ruled favorably for Ristool and the other parties. But how they got there, they relied upon Anishinaabe stories and metaphor to seek what was the Anishinaabe intention in entering into the Robinson Huron treaties. So Heidi Stark, so Dr. Heidi Stark, who I was hoping would be here so I could make fun of, but also applaud her work as an expert witness here, because what she did, she took a story very similar to the one I told you, or for similar purposes, of Buffalo Child, woman who married beaver, and took it back to the court and said, well, here's the legal principles that are in here, and this is how you can start to understand the idea of renewal and respect and reciprocity in our relationship with the land and also with other treaty peoples as well. So she makes this really eloquent argument, and it gets taken up by the court. So I just put this provision here, or this paragraph here, where you can see how the court ruled on that. So all is to say that we are in a moving landscape of Indigenous laws in the courts in Canada today, and it's taken a lot of work for lawyers, for academics, for people in communities. Remember that picture I showed you at the start. I view our elders as the ones who are standing there on that branch and have nursed our legal traditions back to health. It's taken a lot of work to get this to where we're actually having substantive discussions on what are Indigenous legal principles within the court system today. So in the interest of time, I'm not going to go through more of this on this Nunavut decision because I want to make sure that we're moving right along here, and I'm cognizant of that. So before I continue, I'm going to talk about agreements here. I'm just going to give a minute here if you have any questions or comments on what you heard in these cases. I'm also good with awkward silence, so I'm just going to drink coffee for 10 seconds as well. But if you have a question, you can fill that time. Yeah.
I was curious, thinking about language and how that can really change the way that things are understood. And so I was wondering, when you were telling the story about the rock, the buffalo rock, I guess what we were calling buffalo people, but is there really a word for people, or is there, like, how is that concept of personality thought about in your language?
Yeah, that's a great question. So we do have words for people. The word for people is Inu, Inu, and that's kind of shared in a lot of Cree dialects. We have a number of dialects, including people who come out this way. So I mean, it's harder to tell though, because our word for buffalo is Pasquamustus. And then I've never heard people just, because I'm not a fluent language speaker, so I don't know if people are saying Pasquamustus Inu. How we'd actually note that they're peoples would be Pasquamustusak, because that kind of pluralizes it. So that's kind of technical language. But what we do when we think about like the animacy of buffalo or even rocks, we have this concept, it's called the achag, and that is just kind of like an acknowledgement of the spirit, right? And so we have stories where it talks about like who carries spirit, who has the achag, and so it provides that kind of impetus to think of like, oh yeah, this thing is inspirited in some sort of way, and that changes how our legal relationship is with it as well. So, so that's a great question, because I like these stories because they take us to the limit. Like, there's always going to be a mystery on that. Like, even with Heidi's work, like I'll be like, well, what do you mean treaty? What do I mean treaty? Because I even write that. Like, can it be a treaty if another side isn't consenting? How is it renewed, et cetera, et cetera? And what does that language mean? But I also acknowledge that just like if you think about animal rights, the discourse there, the language is sentience. Like, what is a sentient being? Like in those dialogues, like what is ethical consumption, et cetera, et cetera. The language is important there. So the idea of the achag, it's the same sort of thing. It's signaling that you should consider this thing as animate, so to speak. And then, of course, we're relying upon buffalo to eat. So it creates that like foundation for law, and then we have these actually really specific legal discussions in there. Yeah. Any other questions? Yeah.
A very simplistic question, just going off the readings we've done thus far. So last class we were talking more about the Haudenosaunee people, for instance, who don't necessarily want to be recognized by the Canadian courts, and then here we see examples of a progression in the courts where they're starting to recognize Indigenous legal traditions. So is it fair to say that some Indigenous communities see that as a great avenue while others don't, or some would say those are two mutually exclusive goals, but some would say no, this is actually, they can happen in concert so that everyone eventually gets their wishes for what type of legal system they want to see?
Yeah, so that's a great question. So there's two elements to that. I would say the first one is there isn't unanimity in our Indigenous communities. So even in the Cree communities, like I can tell you that story, and then somebody else might tell it and be like, well, this is what I got out of it, or I think you're wrong there. And that's okay, because that's what we do in law, right? You are going to argue about cases in your legal careers. You've done it in your law schools here, and that's what we do. And so you do see that. There are that discourse on like, we want nothing to do with Canadian law. We want to turn inward, because we think that is best for our Indigenous nation, is one sort of way to do it. And another one is like, well, we're stuck in the reality where we do need some sort of recognition from the Canadian state or from a province. So we're actually going to engage in those discussions. And so they do have those, that, you know, that dialogue is very much alive as well. And so, yeah, so the important thing is not to get stuck in the generalization of like, there, even just with specific nations, that there might be a stated strategy for nationhood, but then there might be people within Canadian who, within that tradition, who have different ideas as well. Yeah, so it's complex, but for sure, you're putting your finger on like a dialogue that is for sure continuing in our communities and in academia as well. That's like, we do see that as like people turning towards recognition of Canadian state and Indigenous laws, and then people who are like, don't do this as well. So not to say that they're competing views, but you can look at the work of John Burroughs and then the work of, let's say, Glenn Coulthard. They have the same sort of aspirations for Indigenous peoples, but they do take these two different views of like, one's that inward, we're gonna have resurgence from inside, and the other is like, okay, let's have a revitalization of Indigenous law generally. Okay. So I'm just going to move along here in the interest of time, because I'm like, I know how much slides I have here. We do also have just agreements with Canada as well. So this is the Haida Gwaii. They came up with this agreement based upon their activism on their islands. And but this agreement, it's the Kunstagu Kunstaya Reconciliation Protocol, where they've come up with this co-management agreement of parts of Haida Gwaii with Canada, or with, this one is Canada and British Columbia here. Oh no, I think this one's with British Columbia. Canada actually hasn't come onto this. They leave room actually in this agreement for Canada to be a party of it. But what they're saying is that we are going to set out a way that we can manage these lands. But as you can see in these paragraphs, neither the Haida Nation nor British Columbia lay down their assertions of sovereignty and autonomy here. So they haven't agreed on sovereignty for the Haida Nation. So the Haida Nation says that Haida Gwaii is Haida lands and is subject to the rights, sovereignty, ownership, jurisdiction, and collective title of the Haida Nation. And then British Columbia is saying that it's Crown land, subject to certain private rights and provisions, and then sovereignty, et cetera. So they've come up with agreement. They don't agree on sovereignty, obviously, here. So you may have started to work through those cases. You will in here. But they come up with this agreement. And what we see in this protocol, if you read it, it gives substantive powers for the Haida Nation to legislate and regulate over these lands. So they're allowed to bring Indigenous laws in that way. And then, so then there's other sources of law through legislation. This is by no means a complete survey of this in Canada. Just a few examples. Yukon First Nations have constitutions that bring up their laws. These are according to self-governing agreements, so modern treaties in the Yukon territories. The Constitution of the Haida Nation does the same thing. So again, this idea of assertion of title and sovereignty that is still disputed, but they still have their constitutions, and that the Haida Gwaii is subject to Haida Nation laws. And then you will deal with the Chilcotin case and Aboriginal title and the declaration that occurs there. And flowing out of that, the Chilcotin Nation, they've created their own wildlife law. And this was just last year as well. And they've included substantive areas of their laws on how they're going to deal with violations according to their Wildlife Act. So if somebody hunts in an unlawful way, they have a legal process that's internal to the Chilcotin peoples that they're going to be subject to. And then we're going to fly by here. Okay, I'm trying to time out here so we have enough time for discussion. So that's where we are with like the positivistic and declarative part of Indigenous law in Canada. And then we have these other resources. So going back to this question about norms, we have other sources of law for Indigenous law that aren't just from the legislature or parliament or through court cases or through legislation. We have stories, lands, language, et cetera, et cetera. We have spiritual processes. We have other deliberative processes. So we're starting to find that we're looking for ways that we can look in law, especially in academia, because that's what we get to do. It's a privilege. You get to think about law in a broader sense and come up with sort of identifying theories and philosophies and laws and communities as well. And so this is some of the work that's occurring. Matthew Fletcher in the United States is looking at tribal courts. There's a different sort of relationship with Indigenous nations to states and the federal government in the United States. And so there's a jurisdiction that allows for tribal courts to operate. And what Matthew Fletcher is doing is he's incorporating language, so legal principles within Indigenous languages, and then creating law out of that or making decisions from those as well. So that's Fletcher. Sarah Morales, who is a colleague who works at the University of Victoria and who's Coast Salish, talks about the land and talks about places around her community where the legal traditions are living, vibrant, rooted in histories and landscapes that have existed much longer than 150 years. So that sort of work. The story I told you is an example of that as well from the Plains Cree perspective, that the land provides law. We sometimes talk about it as a mnemonic device. So if I was able to visit the Buffalo Stone, it would recall that story and I'd be able to use that law again as well. And then ceremony, I wrote about ceremony in my master's dissertation, and I see within our ceremonies we actually have legal procedures as well. So I did a lot explaining about that with the tobacco. That's one aspect of our ceremonies, and we can start to pull law out of there as well. And then Val Napoleon and a lot of other scholars are really looking at implicit and informal legal practices. So Val looks at the Gitxsan people. She's adopted in there. She's Saulteaux and Cree and adopted into the Gitxsan peoples. And what she does is she looks at their stories and their art and their oral traditions, and she sees that there's actually implicit law within community practices. So again, this gets to that idea of like how do we demarcate law from norm? And that's kind of like a theoretical question that we won't get into here today. But Val makes a really cogent and really understandable argument on how that is. So I just say if that's your jam, looking into this, look at Val's work. She really does she puts a lot of thought into legal theory on how you can see law in implicit practices. So in summary, Indigenous laws are a part of Canadian law. Courts are increasingly being called to substantively engage with Indigenous laws from a range of sources. So the Stool Case I think it's a great case because it actually is one that pulls law from sources that aren't traditionally used in courts. Laws come in various forms. Some are familiar to the courts and some are less familiar. And then courts will likely continue to be turned to and asked to balance Indigenous legal principles and other Canadian legal principles like the Charter, human rights, and best interests of the child. So we see this in the legislations of the ones that we've referenced, that this is going to come up. Like Indigenous communities are going to make use of these legislations and are going to put forward Indigenous laws. And so the courts need to be ready to make decisions and make interpretations as they come. And then, so we're just seeing this shift in the Canadian legal profession and the judiciary. and this need for strategies and competencies to engage with Indigenous laws as laws. So it's a question of how. It's kind of like my colleagues, Hadley Friedland, Val Napoleon, talk about this question. So in the interest of time, I'm just going to kind of flow through this, but I'm going to just reference this briefly. There's a method, it's called the Story Case Brief method that the Indigenous Law Research Unit, if you're familiar with that, at the University of Victoria uses. And they use stories from communities to provide, to identify legal principles, and then they work with communities to see how those are applicable in certain situations as well. So there's a whole method, and they have a strategy that we won't talk about here because it'll take up a lot of time. But that is one of the sort of like academic methods that's being taken up by law schools, especially today. And I already talked about the linguistic method. And then, so that brings us back to this. So where are we going? So the question, can a rock be precedent? And so I'm not asking you to answer that here. I mean, I probably tipped my hat pretty early to that. But it's just, if this question is actually, it has meaning for the courts, I think we've taken this incremental revitalization of Indigenous laws one step further. So if a court, if the question, so let's say Buffalo Stonechild, that story is brought forward to the court as a way to express Cree law in some sort of manner and to influence a decision, then it means that Indigenous communities and nations are revitalizing legal processes in a formal manner. So we have a way that we're making this cognizable without distorting our legal traditions and making it useful in these debates. They're being applied to contemporary issues. And then the barriers to bring like this story forward has been dismantled. So the Stool Case actually is a great example of this. There's a barrier that has been dismantled somewhere in there on the questions of evidence or even just the cognizability, the competency of the court to receive that. So they're able to bring this question forward. And then if the question is addressed by the courts, it means that there's an understanding of the reasonableness and the justiciability of the question even. I use that in a very broad sense, the term justiciability. We have dealt with the challenges of distortion. So you might be thinking, if you heard that story, if that's brought to the courts, like what are they going to do to it? Are they going to harm that story? Is it going to be distorted, et cetera? If courts have dealt with this challenge of distortion, then we're in a good place. And then finally, just the simple recognition of the significance of the question or the story as well. So that's you know, I don't think that's not like a revolutionary goal. That's one step on the quiet revolution that Indigenous laws are taking in Canada. So that's kind of like the next step is when we can able to use stories like this in various settings in the court. Okay. And then we have the challenges within the courts. So Indigenous laws are unevenly visible, articulated in practices. We're in this process of recovery and revitalization. And then resources is a challenge as well. So the Indigenous Law Research Unit, Val Napoleon would say that it started out as a broom closet at the University of Victoria. And then she just did this, they did this work of funding, and they're continuing to do that work. So for Indigenous laws, there's lots of funding for areas within Canadian justice. So you can think about even just like what it costs to build a new prison, to staff it, and to keep it running. And then you can think about what would that do if a particular Indigenous nation had some sort of funding that was as comparable and sustainable in holding up an area of their law as well. We'd see that change. So that's all just to say that resourcing is actually an issue with Indigenous legal orders. And then we have all these other challenges about writing down laws or not, and how laws are shared as well. So the courts are still challenged with this. Okay, so I'm going to stop there. I know what's coming next on my slides, but I'm actually going to save that to the end to see if our discussion, we might actually go into these areas, or if we have a lull, I'll kind of bring it back to here as well. So, yeah, I just want to open it up to you. Do you have any questions or even just comments on what you've heard? Yeah.
So I'm really interested in and curious about the role of law schools in all of this, and I'm wondering what your perspective is on how well or truly law schools in Canada have addressed the call to action. I'm thinking like specifically here at U of T, certainly we have elements of Indigenous law in the curriculum now, but it would, I think, plausibly be very possible to get a JD without ever actually engaging with Indigenous law beyond someone explaining the distinction between that and Aboriginal law. So I'm wondering what you think the next steps are, and whether there are different ways that maybe different law societies in various provinces have dealt with it, or maybe just even individual law schools.
Yeah. So that's a great question. I'm not going to comment on the U of T experience. I do not have enough information. But part of me being here, I'm going to meet with some staff tomorrow and faculty, and we're going to talk about that as well. So I actually don't know what's going on at the U of T, is what I'm saying. But what I do know is that from my experiences at the U of A and also UVic, and from what I see just from an outside observer in law schools, there's law schools are actually taking this up. They're seeing like, we take this call to action seriously, and we're going to engage with this. What we're seeing is like various strategies that are all over the board in law schools. So if I was to put categories on it, one is like a mandatory course in first year of like Indigenous peoples in the law. That's one strategy that's on the board. The other one is ensuring that Indigenous legal issues are covered in all the core area topics in a first year law school curriculum. And that's another strategy, like kind of a general one. And then the third one is making upper year courses or a suite of courses mandatory that deal with Indigenous issues as well. So those are kind of like the three broad strategies. There's another one that we're talking about at the U of A is as part of a legal foundations course, and I'm not sure if you do that here at the start of first year, making it like a week-long specific, like thinking about Indigenous peoples, but also Indigenous law and Aboriginal law as well. But that one is a lot more work, I think. So those are the three strategies. And I can talk about where we're at with the U of A. We are thinking of the idea that in core courses in the first year, there is teachings on Indigenous legal issues. Constitutional law is the natural fit, but then we're thinking about like, we have to ensure that content is getting to criminal law, to torts even, et cetera, et cetera. So Sarah Morales at UVic, she's teaching in this systemic program and has actually set out tort law, and then has like Indigenous laws on private harms essentially, and working that out. So it's a lot of work to create those courses. And then at U of A, we're also talking about making it mandatory that somebody, in order to graduate, has to take one course in an upper year that is strictly focused on an Indigenous legal issues, because we have the capacity at the U of A. There's 4 faculty who have, I'm not going to say I have expertise in this, but we have proficiency. My colleagues have expertise. I just am loath to say that I have expertise in anything. And we have a variety of courses as well. So I'm teaching an Indigenous environmental law course, a treaties course, a course similar to this, and a Indigenous law foundations course as well. And my colleagues have set out to teach their own courses along there. So we have the ability to offer like a lot of examples at the U of A. So that's what we're kind of doing as well. But it's a slow process. So we have committees and et cetera, et cetera. It'll take years before something solidly is put out there. Yeah. So the quick answer is like, the quick fix would be if people just put in a first year course or a course that's mandatory on Indigenous peoples in the law. But there's drawbacks to that as well. Yeah. So there's another part of that question that I was going to answer, but I dragged on way too long there giving that answer as well. Yeah. Yeah.
I did a lot of like post-colonial theory and did a fair bit of like Indigenous feminist theory. So what I read coming into law school was, I guess, kind of what you were telling Rebecca. I read the Glenn Coulthard article several times in different classes.
Yeah.
Or Audra Simpson. So, and I mean, Audra Simpson like really calls treaties like loose of consent. So, and then I came here and then I learned that, oh, actually treaties should be respected. And a lot of Indigenous people think that they can be good. So, but then I never again learned about the kind of response to that from the likes of Coulthard. So I was wondering if we could talk a bit more about that.
Yeah.
So, and kind of related to that, what you said about seeing culture as a legal principle, that makes sense to me. I'm just like trying to think through like my previous education and just kind of like a post-structuralist view to that. I'm just like wondering if it could be said, not that I necessarily agree, but it could be said that this do you think there is some like respectability politics working through that in the sense of saying that, oh, you're like just like you, this is law, this is not trying to like reclaim these or to be using these authoritative concepts as opposed to say just challenging them.
Yeah, great question. And yes, I would say it is respectably politics for sure. Like, as the use of the word law when we're talking about Indigenous laws, if we say Cree law, what I'm doing is I'm trying to pervade like an authority to that word, right? So in our language, the word for law is wiasawawina, which has a context. I mentioned it's like the act of weaving or braiding. And so when I use that word for language holders, that gives a different connotation than if I was to say law in a law classroom, because then you think of the authority that you put with that word. So I would say yes, but my caveat with that is that how else are we going to be able to describe this, right? And so we can go to the court and say, this is our practice, or the Chilcotin, they talk about it as laying down the stick, their word for law, and they can go to the court and say, well, this is how we lay down the stick, and is the court can actually interpret that and give that effect, right? And so when people are choosing the courts to have it recognized in this way, you're ultimately entering that sort of like idea of respectability, politics or agreements. And so I don't know if I could speak to like what the response would be from, let's say, Glenn Coulthard or Audra Simpson about treaties. But what I would say is like where we get into that like, I don't know, that mushy ground of this is like, is there the questions of like, is it always really terrible to enter into these conversations, and what's the benefit that comes as well? And so, so the polls for that, when I talk about John's work, John Burroughs' work, like he'll say like, it depends is the answer, which is not a satisfying one in law school. He'll say that to enter to use the language of the Canadian state is a tool that has benefit depending upon the situation, or vice versa, to pull away and say, we're not going to deal with this at all, we're going to use our own inherent laws and we're going to use our own inherent languages. It depends on the situation. So I know that's not a satisfying one here, but I actually do believe that. Like, we're always going to be stuck if we're, like for our communities, so I'm just thinking for Plains Cree peoples, if we are we're stuck if we just look at our own internal laws, but we need to actually have a treaty interpretation. Canada isn't just going to be peering over our shoulders and being like, okay, I get it now, right? We actually do have to engage in that discussion of like, here's what treaty is, et cetera, which ultimately has that effect of like the challenge of distorting what we mean by treaty, essentially. I knew this wasn't going to be a satisfying answer to that, because it's one of those questions that's right in the gray area as well. So by the way, my law students at the University of Alberta last class, like we're talking about Section 35 and Aboriginal rights in Vanderpeet, and they're coming to this awareness as well. They're in law school and they're walking out of the class like, well, what are we doing? Like, is this just going to harm Indigenous communities by doing this? And it is the challenge that we're dealing with, right? How do we engage in this structure that has been really harmful, and can it change? So those existential questions, I don't want people to turn away from law because of it, but I do think they're actually really important to understand. Yeah. I don't know who had their hand up first. Okay, we'll go back there and we'll come here. Yeah.
Yeah, thank you. As I could speak briefly to your view on the best place for non-Indigenous individuals and lawyers in terms of Aboriginal law, and how such lawyers can also then best engage with Indigenous law as well. Which of course begs how much overlap there actually is between Aboriginal and Indigenous law, but for people who are interested in perhaps being involved in Aboriginal law in the future but don't have an Indigenous background.
Yeah. That's a great question. I mean, I'm trying not to give unsatisfying answers. I think that like learning is, it seems like a simple answer. Like listening and learning for non-Indigenous peoples about Indigenous peoples is just essential. And so I haven't really reflected on having a view of whether like non-Indigenous people can practice in Aboriginal law. Mostly because the reality is we need people to be practicing that and who come into these classes and have this understanding, and we have this changing environment. But I do think it's important how we engage. So if you're a practitioner, and even if you're Indigenous as well. So for me, how do I engage, let's say if I'm dealing with issues that are pertinent to the Wet'suwet'en people. It still provides, that's not my home nation obviously, it still provides an impetus for me to continue to learn about the people, learn about their laws, give space for them to speak, take their instructions seriously, even as hard or as it may be. So if they're saying, and what I mean by that is if there's a community that is saying, we actually want to talk about this law that is really specific to our nation here, is to, as a person working for them, to be like, okay, how do we make this work, right? To really uphold those sort of ethics as a lawyer are really important as well. So I know that's kind of just like, it seems like it's a slogan advice you'd put on your mirror and say every morning as going to work as a lawyer, but I do think those are the important things if you're working in Aboriginal law. And I'll say this, because in my classes, I say this at law school, there will be people who end up working for provincial and federal crowns. It's equally vitally as important as well when you're doing that work, to continue to learn about Indigenous peoples, to learn this history, to learn about Indigenous laws, and to go forth in that sort of manner as well. Yeah. Thank you.
I'm just wondering if you think the path courts are going on when they handle Indigenous law is the right way to do it. I'm looking at the Stool Case, and I guess we had an expert that gave testimony about the woman who married a beaver. I guess that was a legal tradition. My understanding is that experts are not supposed to speak to law. That's the role of judges. So this is sort of an admission that the expert's testimony, this principle, does not affect law at all. So I'm wondering if you think that's...
Yeah, and so, I mean, I think we would disagree on how they use the woman who married Beaver there. So they're not saying, oh, this is the actual law, but what it was doing was providing a reference for the common intention of the Anishinaabe peoples there. And so, and it was using very specific principles within that story. So like reciprocity, renewal, respect. So it wasn't necessarily saying, oh, this is our law from the story, but it was saying this is going to be a way that we can, the courts can account for this as well. And I think the treaty case is a special example because it's written there that they have to seek the common intentions within treaty interpretation. Yeah. So that's, I mean, that might be a small point, but we have this idea of like, what does an expert witness provide? Can they provide evidence on the history of a legal relation, or are they providing evidence on the law? So that's actually a debate that's ongoing in a lot of these cases, because when they're going back, especially the nature of Section 35, you have to prove this prior to contact, or in Métis, it's post-contact but pre-effective control. So if you're going to argue a law, like we have a right to govern through law, then you're going to need a witness, an expert witness who's going to provide evidence for that. So that is the question, exactly what you're saying, is like, how do you provide evidence of a historical law by not violating this rule that you can provide evidence of law, right? And so there's actually some good articles out there that talk about that. I think Kent McNeil has written one where he's addressing that question specifically. Yeah.
Just add something on that.
Yeah.
It's somewhat similar to the question about how you prove foreign law in a situation where foreign law matters to the outcome in a domestic court. And the usual rule is that foreign law is assumed to be the same as the law of the forum, except to the extent that you can prove as a question of fact by expert evidence what the foreign law is. So in that situation, the foreign expert is speaking as a matter of fact to what the law of a different jurisdiction is. So if your view about Stool is that that's what's going on there, then you can see Dr. Stark's testimony or evidence as evidence about Anishinaabe law to the extent that Anishinaabe law is relevant. And seen that way, it's relatively consistent with the role of an expert in a proceeding such as that.
Yeah, thank you. Any other, yeah.
This is actually all the way back to the TRC slides, but it said
Yeah.
The 42nd call, and that was the implementation of an Aboriginal justice system. And my quick question is just what would that look like?
Yeah,
I'm
that's a great question.
the specific recommendation of the TRC, and I'm just curious what that was.
Yeah, I think we're still working through like what we mean when we say Aboriginal justice system. My inclination, it's building on this tradition of talking that way. I think they're really thinking about criminal law. Like how do we have Indigenous legal processes within criminal justice, the criminal justice system essentially. So I think that's where that comes out of. How that looks, we have various thinkers on that. Harold Johnson just came out with a book. He's Plains Cree, and it's called Peace and Good Order, when he's talking about like having an Indigenous justice system and the need for that as well. So I couldn't tell you like what the line exact, like what they're thinking, because that is actually something that is just like a broad conversation that's ongoing, right? And I haven't heard, there isn't like a consensus on like, oh yeah, this is what it needs to be. But we have seen where Aboriginal courts have popped up really regionally. So Alberta is an example. We had a Tsuut'ina, which is a Dene nation in the south. They had their own courts where they had processes that are similar to Tsuut'ina law in provincial court, but it still was just part of the provincial court as well. So it still got its powers from the provincial court. If offenses were too large, they would go to provincial court, et cetera, all these sorts of things, right? Yeah, so unsatisfying again, yeah. It's really is this, like, this call to action is like from such a, all the other ones as well, like, we need to have the restoration of Indigenous law, right? Those are large, it's a large call. So what we've seen on the ground is either just like large theorizing on what that looks like, or when it has been put in place, it's in very localized areas. Yeah, there's been no commitment from a provincial or federal government to fund billions of dollars towards an Indigenous justice system.
So we're at 10 to 6, so you're free to go if you want to, but before you do, let's thank Professor Lindberg for his talk.
Thanks for having me.
If there is interest in continuing the conversation informally until, say, 6 o'clock, if you're willing,
Yep.
people who want to stay can, but you're free to go if that's what you want to do.
And my feelings won't be hurt if you have to go. But well, yeah, we can continue with questions.
My question is related to Robert's question. I haven't read the Stool Case, so I don't know if this is irrelevant, but if by recognizing the expert testimony about the story of Holland and Beaver as akin to a foreign expert testifying about foreign law, is the court kind of opening the doors to the claim that separate that we need to recognize as this other legal source?
Yeah, so that's a great question. So I won't talk about the foreign law thing, but I do know Stool, I don't think they mentioned this in that about foreign law, or I'm not sure. But the court has said in other cases, so Beaver and Hill, that Indigenous law, it's not foreign law. It's actually like internal here because they're using this sort of interpretation of whether that was. But I don't know if you want to comment on the
I was
foreign
just going to
aspect.
add what you said about Beaver and Hill. Beaver and Hill, just so you know, is a messy child and family support dispute between two Haudenosaunee people, one of whom wants it dealt with under Ontario and Canadian law, and the other wants it dealt with under Haudenosaunee law. The judge of first instance had used conflict of laws principles to decide that Haudenosaunee law was not appropriate for this case. The Ontario Court of Appeal said, in the context of Section 35 of the Constitution Act 1982, Indigenous law, Haudenosaunee law, is not foreign law. So it has to be dealt with as domestic law. They didn't say what that meant, but in future proceedings where Mr. Hill, who wants to rely on Haudenosaunee law, is asserting an aboriginal right to have the matter dealt with under Haudenosaunee law, perhaps we'll get some clarification.
I have a question about something you said earlier. I think it was also in the readings about, I guess, how different people can share a story in a different way. Is there some common agreement as to the principle or the value that comes out of the story, or are the disagreements mostly about like the details, like the facts of the story, or how to apply it to a certain context?
Mm-hmm. Well, I mean, I think the stories, so here's the challenge with the case brief method that we use in law schools is like, sometimes stories are pulled out for different events. So it's like, the metaphors or the analogies often work, but sometimes they don't. Like in Canadian law, you can have a case that is like it's a precedent for one certain area of law or a certain question of law, and then in another area as well. So the same case can do that. Our stories do that as well. They can be applied in other settings. So for example, John Burroughs and I, we talk about a similar story for different meanings, but it doesn't mean that one is better than the other. So that occurs. So it's more of like a fluid understanding of like the resiliency and the flexibility of stories. But what you're putting your point on is stories are often invoked to create like a conflict. So sometimes it's in our older traditions, stories were brought out in order to address a problem, but not necessarily like harm somebody. So it's like, I'm going to tell you this story. So we might have an interpretation on what that means or specifically. So we do have stories that are applied that way. So there's a rigor to it. But the thing is, we don't have like a tradition of like precedent with stories where, you know, there's not a decision. That story, it's no good anymore and it's kicked out, you know, that we do for case law. So there's a difference there. So I do find the analogy. It's great for like the initial recognition of some parts of law, but then it quickly loses ground there. Yeah.
Something I was thinking about when I was doing the reading from the different worldviews is that in Canadian law, we kind of have this like general understanding of secularism in law, or like a separation between like a religious neutrality, I guess. And so my understanding of Indigenous legal traditions is that, like generally speaking, there is more of an overlap or less of a clear distinction between sort of spirituality and religion and like hard law, I guess. And so to the extent that you're trying to like integrate Indigenous legal traditions into Canadian law, does that create problems potentially, or like how can that be reconciled?
Yeah, that's a great question. So one of the challenges is that it's like cognizability by a court system or even a law school. If there's like law that's sourced from a sacred story, so that creates a challenge there. And part of that is the idea of like reasonableness. So how we negotiate how a court is going to work through that. We'll figure that out. So that's a challenge. But drawing back to what you're talking about with the split in Canadian society between like religious and political and law, if you look at the history of why that is in Canada is different from Indigenous context and history as well. So you see the language, it's Leroy Littlebear talks about like religion. And we actually have thinkers who say, well, our spirituality actually isn't a religion, it's a spirituality. And it has, even though we talk about, some stories will talk about the creator or a law might come from a sacred source, it really is not this sort of like authoritative, you know, Moses with the tablets sort of way of thinking. It's actually just one source that influences law. And so actually John's work in your readings is really good for that when he talks about like, we have to be careful not to fall into our own traditions of originalism with Indigenous law. And what he's saying is like, I can't remember what he says, but he's like, we have laws that are traditional, and then we have contemporary times, and we have the history in between. And then like a tree, we can't put all the pressure on just one point. We can't just put it on the branches, the trunk, or the roots, but it has to be all over that as well. And so, and I think that's actually a recognition like a lot of Indigenous legal scholars have. So they recognize that we have this talk of spirituality in our laws, but it's also just commingling with all these other legal sources as well. That's really important. So yeah, so it hasn't created, we do have debates of like originalism and fundamentalism for sure in our communities, but it hasn't created the same sort of discourse you see in Canadian law, that it's been like, we need to keep these completely separate. Yeah. Maybe we'll get there someday. I don't know. Yeah.
Has the TRC had any impact, as far as you can tell, on judicial appointments? Like, have we seen any change in terms of demographics or anything like that? Do you think that would be important to?
Yeah, it would be really important. I don't know for the appointments. I couldn't tell you. I don't have that knowledge. I know they didn't appoint us Indigenous Supreme Court Justice last chance around. But I don't know like what's going on in the ground. We do see like a lot of uptake of Indigenous peoples going to provincial courts, for example. But I think that's just more of, we're just having more Indigenous legal scholars, lawyers, et cetera. It's more of a product of that. But where we do see it is a judicial teaching. So in that Stool Case, I know Val Napoleon, they did like similar workshops based on what we're talking about here with these judges, just to have that understanding of Indigenous laws that's occurring. Next week, I'm talking with having a presentation like this in front of 150 judges as well. So we're seeing the judicial education is actually where it's changing because they recognize they have to take this up. Yeah.
I think we'll call it there because there might be a class in here at 6:10 and the video folks need some time to take their equipment apart and vacate.